when you picture, you know, big patent battles, you probably think of, small companies taking on these huge corporations, right, in a U.S. court somewhere. But um, today we're actually going to China.
Yeah.
A pretty compelling, I think, David versus Goliath kind of story. And the Goliath this time is Apple.
Interesting, right. And what really grabs me about this whole situation with Apple and their legal stuff in China is how many different angles there are to it. It's
Mhm.
not just the usual, patent back and forth.
Yeah,
There are some serious questions about whether they're, acting like a monopoly.
exactly. And that's kind of, I think, why we're doing this deep dive, right? For those listening who want to really understand this without getting lost in the weeds, right?
Yeah.
We've gone through a bunch of different articles and reports that look into Apple's legal troubles in China. So we're talking disputes with companies like Citi and Jitong, which is a name we're going to hear a lot,
Yeah.
and some potentially, concerning stuff about the fairness of the legal system itself.
Yeah, absolutely. It's like big picture.
Yeah.
The goal is kind of to understand these major legal things that Apple's run into in China. What are they actually disagreeing about? And then what does all this mean for innovation and the legal system there and maybe even beyond?
Right. And we want to keep it interesting,
For
zoom
sure.
out some of the surprising things and definitely avoid, getting bogged down in the legal jargon.
Agreed. Yeah, no one wants that.
Okay, so uh, let's start unpacking this whole thing. And I think a good place to begin is with what's being called the Apple tax case.
Okay.
So back in May 2024, the Shanghai Intellectual Property Court came out with its initial ruling, what's called a first instance ruling,
Yeah.
in a case that a consumer named Jin brought against Apple.
Right. So to get this, you kind of have to understand what Jin was suing about.
Yeah.
It all boils down to Apple's 30% commission on in-app purchases,
Right.
which is, the infamous Apple tax.
Yep.
So this lawsuit was saying, hey, that's unfair pricing.
Right.
And they were also objecting to Apple forcing developers to use its payment system.
And the lawyer for Jin's,
Yeah.
right, they were not subtle about this.
Oh, yeah.
I mean, they flat out said that China's getting a raw deal,
Yeah.
that they have the highest Apple tax anywhere in the world.
Right.
And they're even planning to appeal this all the way up to the Supreme People's Court in China.
Wow. Yeah, that's a big deal.
Huge.
And what's even bigger is the basis for that appeal.
Right.
They're basically saying Apple's leveraging its dominance to stifle competition, limiting choices for consumers and creating an unfair playing field.
Right.
Plus, they claim it makes things more expensive for companies in China and hurts their industry's competitiveness.
Wow. So, yeah, this is not a small accusation.
Absolutely not.
Now, this is where it gets really interesting.
Okay.
The initial ruling actually went in Apple's favor, and one of the sources points out that maybe that wasn't so surprising,
Okay.
given that Shanghai is, well, kind of like Apple's home turf in China, right?
Yeah.
It's a hub for foreign investment,
Right. Right.
so maybe not unexpected.
Mm.
But if we zoom out and look at the bigger picture, this ruling actually seems to buck a global trend.
Oh, really?
Yeah.
How so?
Well, if you think about it, we're seeing regulators everywhere taking a harder look at these, potential anti-competitive practices by big tech companies,
right.
right? Apple, Google, Microsoft, Amazon, all of them.
Yeah.
So the author's suggesting that China right now seems to be one of the more accommodating places to be.
Interesting.
Yeah.
So like a safe haven almost.
Kind of, yeah.
Yeah.
And they go further. Actually, they suggest that Apple generally comes out on top in most of their major legal battles in China.
Mm.
Only a handful of losses that actually had a real, substantive effect on the business.
Okay, so what are they talking about?
Well, a big example that's given is Apple's loss to Citi and Jitong back in late 2022.
Right.
Remember that name we mentioned before?
Yeah, the 817 case.
Exactly, the 817 case.
Yeah.
And in that one, Apple actually had to pay something like 140 million yuan.
Wow. That's a pretty big chunk of change.
Right. It really stands out as a notable case where they did lose
Yeah.
and had to pay up.
Big time.
So the fact that Apple seems to consistently, perform so well in Chinese courts,
Yeah,
especially in these big cases, has definitely caught people's attention.
I bet.
And it's interesting because the Supreme People's Court in February, they actually released their list of the top 100 cases in 5 years.
Okay.
And guess what? 3 of those cases involved patent disputes with Apple.
No way.
Yeah.
So what happened in those cases?
Well, here's the key thing. Apple lost all 3.
All 3.
All 3 at the Supreme Court level.
Wow.
So besides the Citi and Jitong case,
Right.
there was an appeal in an administrative case about facial recognition
Okay.
with the tech company Beijing and another appeal with Qualcomm.
Right.
This one was about how activity cards work on devices, you know?
Okay.
So 3 strikes and you're out.
Wow, that's fascinating.
Right, and get this, that facial recognition case was also highlighted as one of the top 10 intellectual property cases of China's courts in 2023.
Oh, wow.
Yeah, so they're definitely paying attention to this.
Yeah.
Now, if we go a bit deeper, right,
Yeah.
we actually see other cases with Apple that were made public back in February on the China Judgments Online platform.
Okay.
So, for instance, another administrative appeal between an independent inventor named Yan and Apple.
Okay.
And in this one, the Supreme People's Court actually sided with Yan.
Uh-huh.
So they rejected Apple's appeal and upheld the decision that Yan's patent was valid.
Interesting.
So, on the surface, these public losses might make it seem like,
Oh.
oh, Apple doesn't always win in China, right?
Yeah.
But the author we're looking at, they offer a different take
Hmm.
on these, what they call non-substantive effect cases.
Okay, so help me understand that.
Yeah.
Like, what's the argument?
Well, the key thing is that these cases are often just steps, in a longer process
Okay.
that the author calls reverse hijacking.
Reverse hijacking.
Okay. So these might be challenges to, whether a patent is valid or just administrative procedures.
Right.
But they don't always lead to those final judgments
Okay.
where Apple has to actually pay significant money.
Gotcha.
You know what I mean?
So it's not the end of the story.
Exactly.
So it's a chapter.
Yeah. And so they're basically saying these cases don't really tell us if Chinese patent holders are going to be successful in the end,
Okay.
when it really matters.
Mhm.
When it comes to getting real financial compensation from Apple.
Yeah, that makes sense.
And this connects to what the author calls the Apple dilemma,
Okay.
which is something they talked about before in the context of companies that don't actually make products,
Right.
like those, what are called non-practicing entities or NPEs,
Yeah, NPEs.
trying to get money from Apple in China using patents.
Right.
So the idea is,
Yeah.
can Chinese innovators actually get paid for their inventions,
Yeah.
especially in these final legal battles?
At the end of the day,
If they can't, that's a problem.
right.
Yeah, that's a huge problem.
Because it could actually mean China loses out, even with,
Right.
Apple being such a big presence there.
It disincentivizes innovation,
Exactly.
domestic innovation.
Yeah. All right. So that kind of gives us some background
Yes.
on the Apple tax and these patent fights.
Yeah.
But let's dive into what's happening with Sidian Jitong,
Okay.
because this is where it gets into some pretty serious allegations about influence within the legal system.
Oh, okay. Lay it on me.
So what's going on is there's this whole controversy brewing
Yeah.
around claims that a professor of intellectual property law at Peking University,
Oh, okay.
Beta,
Beta. Yeah.
acted improperly,
Oh, yeah.
maybe as a judicial broker,
Hmm.
and was involved in some academic misconduct.
Wow.
And the key thing here is that Sidian Jitong is the one who reported these allegations.
Interesting.
So there's this article making the rounds.
Okay.
It's called Exploring the Story Behind Sidian Jitong's Aru Against the Peking University Professor.
And this article really digs into some, suspicious coincidences.
Okay, so what kind of coincidences?
Well, the big one is that many of the key players involved in all of this,
Yeah.
they're all graduates of Beta's law program,
Oh,
specifically in intellectual property.
so they all know each other.
Exactly. And the way the article puts it is that it creates this,
Yeah.
tightly knit community of interest.
Mm,
You've got professors with, big influence in academia,
wait.
judges with power, lawyers who represent these multinational corporations like Apple,
Mm-hmm.
legal experts who work with local research companies.
So it's all very insular.
Right. And the article asks, does this kind of closed network inevitably create a situation
Yeah.
where they're looking out for each other
Right.
to the detriment of fairness?
Yeah, that's a big question.
Right. So the article lays out what it calls a
Go ahead.
1 stance plus 2 doubts plus 4 pieces of evidence framework
Okay.
for these allegations. And it's all very serious stuff.
Yeah. Wow. So let's start with the one stance then.
Right. The seemingly contradictory opinions of the Beidou professor.
Okay. So what's that all about?
What comes down to the professor's expert opinions about Sidian Jitong's WAPI technology.
Okay.
So in a case between Sidian Jitong and Sony,
Mm-hmm.
the professor reportedly gave a favorable assessment of Sidian Jitong's licensing fees for WAPI,
Okay.
saying they were reasonable and fair.
Right.
But then during the appeal stage of the Sidian Jitong versus Apple case,
Yeah.
the same professor
Oh.
publishes articles arguing that those same Obia Jitong fees are way too high.
Oh, wow. So a complete 180.
Right.
That's a pretty big shift.
Huge, and it really raises questions about consistency and potential motives.
Absolutely.
Were these changes influenced by any kind of personal interests?
Right. Like, were they a judicial broker?
Yeah. And here's another layer to this.
Okay.
About 9 years ago, during that Sony case,
Yeah.
it's alleged that the professor asked Zitian Jitong for expert fees. And supposedly this was done through a lawyer acting as a go-between.
Okay.
And the payment was even initially directed to the lawyer's personal account.
Really?
Yeah, and then in the Apple case,
Yeah.
there's this claim that the Beata professor tried to set up some kind of business relationship with Zitian Jitong.
Hmm.
But when that collaboration fell through, guess what?
What?
The professor then publishes those critical articles.
Oh, wow. That's really suspicious.
Right, it's very suspicious.
Yeah.
So the timing of all this really makes you wonder.
Absolutely. Yeah. What's the connection there?
Exactly.
Okay.
Okay, so now let's get to the first of the two doubts.
Okay. The doubts.
Yeah, so the question here is, how did someone who wasn't actually part of the legal proceedings
Right.
know things about the trial that weren't public knowledge?
Okay. So who are we talking about?
Well, the Beta professor.
The professor. Got it.
So in the report filed by Zitian Jitong, they claimed that the professor approached their chairman
Uh-huh.
to talk about the appeal while it was still happening.
So, like, how did the professor even know about that?
Right. How would they know the specifics? And even
Yeah.
more, how would they know that a specific judge,
Yeah.
who also happens to be a Beta graduate
Mm-hmm.
and is said to be close to the professor, was the main judge
Right.
for the Apple case?
That's a good question.
Like, this kind of information about who's on the appeal panel,
Yeah.
it's not typically public, you
Yeah.
know?
Right.
So for someone outside the courts to have that,
Yeah.
it implies some kind of inside connection.
Absolutely.
So if we think about where this information might have come from,
Yeah.
besides Shidi and Jitong themselves,
Right.
it could be Apple,
Okay.
the law firms involved,
Mm.
or even someone within the court system.
Right.
And the fact that the judges on the appeal panel for the Apple case weren't actually publicly announced
Yeah.
makes this even more concerning.
Sure, for sure.
So this also kind of touches on broader worries about how secure information is in these legal cases. The author brings up the patent dispute between OPPO and Nokia
Okay.
and how Qualcomm seemed to know the ruling date in another case ahead of time.
Wow.
That's not a good look.
No, it sounds like there might be a pattern.
Right. Okay, so now the second doubt.
Okay, me.
This one focuses on what might be the real heart of the report against the professor,
Okay.
while it's like aimed at the individual.
Yeah.
The constant mention of the appeal case
Uh-huh.
suggests that the bigger problem might be with the fairness and integrity of that specific ruling.
So they're using the professor to get at the ruling itself.
Kind of, yeah. The question is, did the professor's actions somehow influence the outcome of the appeal in the Apple case?
Okay, now remind me what happened in that appeal.
When that appeal, Zitian Jitong won.
They won.
They won, and they were awarded 142 million yuan in damages
Wow.
after a 7-year legal battle.
That's a long time.
Right.
So why is this so important?
It's important because it's presented as this really rare instance, maybe even unique, where Apple lost a patent infringement case in a Chinese court,
Oh, wow.
and they had to pay a Chinese innovator
Yep.
after a full legal process,
That's huge.
right? The author contrasts this with all these other cases
Right.
where Apple, they challenged the validity of patents successfully or were found not to have infringed.
Right.
So cases involving like Sun Gegrui, Yu Jun, Ren Xiaoping, Yan Yizhong, the U.S. company GP&E.
Gotcha. So Apple basically won all those.
Yeah, pretty much.
So this makes Zitian Jitong a real outlier.
Exactly. And it leads to the question of whether Apple has some kind of protection in China
Interesting.
when it comes to patent threats. They just
Mhm.
seem to do so well.
Yeah.
And it's interesting because even though Shidi and Jitong won the 8 and 17 case,
Yeah.
the author points out that the court was initially hesitant
Yeah.
to release details about the case,
Right.
who was involved, the full judgment.
Like they were trying to keep it quiet.
Yeah, kind of.
Why would they do that?
Well, the information only started to come out later,
Okay.
during the 2 sessions.
Right.
That big political event in China,
Right.
when they released some typical case examples.
So it's like they didn't want to draw attention to it.
Right, it makes you wonder what was going on.
For sure.
Okay, so let's look at these 4 pieces of evidence
Okay. The evidence.
that are mentioned.
Lay it on me.
The first one is the broker behavior during the 817 case.
Okay, so what does that mean?
Well, remember the claim that the Beta professor showed City Jitong's chairman these chat records
Right.
that supposedly show the professor could influence judicial cases.
Yeah.
So the question is, was there a connection between the alleged, failed business cooperation between the professor and City Jitong
Right.
and the fact that the professor then published these negative articles about City Jitong?
Okay, yeah. Timing is everything.
Right, exactly.
Interesting.
Okay, so the second piece of evidence,
Yeah.
this involves the actual records from the 817 case.
Okay.
So the suggestion is to check if the professor's articles about WIPI
Yeah.
were mentioned in the official case files, and importantly, in the notes from the judge's deliberations
Okay.
during the Apple appeal.
Right.
And the author points out that these deliberation records, they're kept in what they call Volume B.
Okay.
And that's usually not accessible to the people involved in the lawsuit.
Right, but if you were investigating this,
Yeah.
you could look at that.
Right, and see if the professor's arguments actually influence the judges.
Right.
So the third piece of evidence
Yeah.
seems very connected to the second one,
Okay.
is a deep dive into the 817 case judgment itself.
The judgment. Okay.
Yeah, so the idea is to really scrutinize the appeal judgment,
Okay.
all the legal documents,
Uh-huh.
and look for flaws in the reasoning
Right.
or the logic.
And see if there's anything that seems off.
Exactly. And the key question is who benefits from those flaws,
Oh, I see.
right? Like maybe there's more to this judgment
Yeah.
than just the money.
Interesting.
Yeah. And then finally, the fourth piece of evidence brings us back to those supposedly contradictory opinions from the professor
Right, about the WIPI technology.
in the Sony and Apple cases.
Right, right.
You know how their views seem to flip-flop?
Yeah, totally.
So the author points out that in the professor's updated online article,
Okay.
they mention visiting City and Jitong for research.
Right.
But the original version also mentioned visits to Apple and Samsung during the 817 case.
Oh, wow.
So what were they doing there?
Yeah, like what was the purpose?
Exactly. And how does that connect to their public statements?
Right.
So yeah, it's pretty messy.
It really is. It sounds like there's a lot more to this than meets the eye.
Absolutely. This whole Boyita professor situation is,
Yeah,
a can of worms.
big time.
Okay, so now let's get to another layer of this.
All right, what else is there?
Apple's attempts to stop the public disclosure of court judgments.
Oh, wow. Okay, so fill me in.
So in November 2024, a lawyer's letter
Okay.
from the Shanghai Fangda law firm
Uh-huh.
was sent to City and Jitong,
To City and Jitong.
demanding that they stop, violating confidentiality agreements
Okay.
and infringing on trade secrets by making these judgments public.
Interesting.
So City and Jitong actually shared this letter
Oh, they did?
on their official WeChat account.
Wow. Bold move.
Right, and they explained that they wanted to inform people about potential legal risks, being transparent and acting in good faith.
Right.
So while the letter itself didn't name the company,
Okay.
it's pretty heavily implied
Yeah.
that the certain company was Apple.
Right. Given Fangda's history with them.
Exactly. So this is seen as another,
Yeah.
chapter in the saga.
Following the report about the professor?
Yeah, after the report about the professor. And it suggests that tensions are still high.
Yeah.
And this isn't the first time they've butted heads.
Oh, really?
The author mentions a confrontation that happened 7 years before at a China patent annual meeting
Okay.
between City and Jitong and Apple's Chinese lawyer,
And who was that?
also from Fangda.
Oh, wow. From the same firm.
Yeah. But this current situation,
Yeah.
it's much more drawn out
Okay.
and wider reaching,
Mm-hmm.
and it hints at something deeper.
Yeah.
Like
Right.
there were bigger issues here.
With Apple and the courts.
Yeah, with Apple academics, law firms, and potentially the courts themselves.
That's a big deal.
It is. And the author argues that this whole escalation
Yeah.
from this little disagreement to this huge problem,
Right.
it contradicts the Supreme People's Court's whole idea of resolving disputes locally.
Right. That Feng Kao experience.
Exactly, the Feng Kiao experience.
Interesting.
And this brings us to this concept of Apple's reverse hijacking strategy.
Reverse hijacking. Okay, so what's that about?
The idea is that Apple uses its legal muscle and the legal process itself to exhaust patent holders,
Okay.
especially small companies.
Right.
So it makes Apple a focal point
Yeah.
for IP disputes in China
Okay.
and could lead to, really bad outcomes for these smaller players.
Right.
So research suggests that globally, it takes Apple, on average, about 42 months to hijack judicial proceedings
In patent cases.
in patent cases.
Okay.
But in China, the recent cases, they've averaged like 120 months.
120 months, that's 10 years.
Yeah, 10 years.
Wow.
And many of them are still going on.
That's a really long time.
Right. And we have examples of Chinese innovators facing, huge obstacles, protecting their rights against Apple.
Yeah, give me an example.
Well, there's Ren Xiaoping,
Okay.
who talked about the long and drawn-out process of challenging Apple's patents
All right.
and how Apple uses delaying tactics successfully.
And they get away with it.
Yeah, supposedly because the fees for these challenges are so low, and they exploit loopholes in the system.
That's really frustrating.
Right. So the main concern is that Apple's setting this dangerous precedent
Right.
for other big companies,
Yeah.
encouraging them to just avoid paying for patents.
By doing the same thing.
Yeah, using this aggressive reverse hijacking.
Right. So that could really stifle innovation.
Right.
Exactly. If you're an inventor and, you face a decade of legal battles
Yeah.
with an uncertain outcome.
Who would want to do that?
Right.
Wow.
You're going to be less likely to invest your time and money in research and development.
Right. It just makes more sense to not even try.
Exactly. And then the author compares this to Qualcomm.
It's Qualcomm. Okay.
Yeah. How Apple and Qualcomm impact Chinese innovation.
Interesting. Okay.
So Qualcomm charges a lot for their patents.
Right.
But the argument is that this might actually incentivize Chinese companies to develop their own technologies.
You compete.
Yeah, like chips.
Right.
So they're not so reliant on Qualcomm.
So the financial impact is there,
Yeah, it's big, but it's measurable.
but you can see it.
Exactly.
Okay.
But Apple's different.
Right. They don't directly charge, but
They use reverse hijack.
reverse hijack.
And this could have a much worse effect on innovation.
Yeah.
Because it discourages it from even starting.
Right.
And the author links this to a report by that U.S. tech think tank, IDIF.
You know the one that talks about strategies to slow down China?
Right.
And they say reverse hijacking fits right in
Oh, wow.
with that goal of hindering Chinese innovation.
Interesting.
So going back to Apple's lawyer's letter,
Right. The one about confidentiality.
yeah, demanding that Jidi and Jitong not disclose these judgments.
Right.
The author questions whether that's really the main reason,
Okay.
keeping things confidential.
Right.
They suggest it might be about creating more legal procedures.
Wow. To drag things out.
Yeah, as we've talked about, that benefits Apple
Right.
in these drawn-out disputes.
Absolutely.
And they even suggest that Apple's legal costs in China
Yeah.
might end up being higher than the patent fees they would have paid if they had just licensed the technology.
Wow. That's kind of ironic.
Right. So the big worry here is that if the patent system doesn't actually benefit innovators,
Right.
but mainly the lawyers defending these big companies,
Yeah.
China's ability to compete with the U.S. technologically could be seriously hampered.
Makes sense. Like they're shooting themselves in the foot.
Right.
Okay, so what's this Fenkyo experience all about?
Well, the Fenkyo experience is this idea of resolving small conflicts locally.
Locally, okay.
Yeah. So you prevent them from growing into these huge issues,
Right.
and you find solutions within the community.
So keep it small.
Yeah. It started in the 60s in Zhejiang province,
Okay.
and it involves getting everyday people to resolve disputes locally.
So less need for the government to step in.
Exactly.
Okay.
And the Supreme People's Court has been emphasizing this,
Right.
making sure judicial decisions are fair and accepted by the public.
Yeah.
So really solving disputes and making people feel like they've been treated justly.
So how does this apply to intellectual property?
Well, the author says IP adjudication in China
Okay.
really needs to embrace this Fenkao experience
Okay.
because small IP disputes can easily escalate into major problems.
Right. With big consequences.
Yeah, and they bring up the Lang Wine trademark dispute
Mhm.
as a recent example of concerns about court fairness
Right.
and local interests being protected unfairly.
So a local dispute turning into a national one.
Exactly.
Gotcha.
And it highlights how these local things can get national attention
Right.
and create doubts about the legal system.
Yeah, that makes sense.
So going back to Apple's alleged reverse hijacking,
Right.
the author says it's gotten a lot of attention
Uh-huh.
in China and internationally.
Especially because these cases take so long.
Exactly. These cases in China drag on much longer
Yeah, compared to other places.
than similar cases elsewhere.
Right.
And this lengthy process,
Yeah.
it contradicts the Fenkao experience
Completely.
completely.
Yeah.
So the question is, why hasn't the Citi and Jitong and Apple dispute been resolved,
Right.
even after the Supreme People's Court appeal ruling?
Yeah, like shouldn't that be the end of it?
You would think so.
But it's not.
But there are still legal actions going on,
Like what?
like Apple's renewed anti-monopoly appeal. Samsung's lawsuit about licensing fees.
Right.
So it's not over.
It's like they're not giving up.
No.
So who or what is giving these big foreign companies like Apple and Samsung the confidence to keep challenging Zitian Jitong's fees?
Right.
Like, these fees are supposed to be fair and reasonable.
Frand.
Yeah, FRAND. And they were determined to be FRAND.
Right.
And it happened across multiple legal fronts.
Yeah, and even after a ruling from the highest court.
It's wild.
Right. So the authors suggest this is becoming a negative example of the Fincale experience.
Oh, yeah, I see that.
And Zitian Jitong's recent actions,
yeah.
reporting the professor making judgments public,
Right.
are also kind of moving away from that.
What about that local resolution?
Exactly.
Hmm?
So the author believes that Apple, being a,
Yeah.
upstanding company,
Reputable? Yeah.
would probably respect and comply with rulings
Right.
if they were clear and final.
Expert.